Well, tension over the Cowichan land title ruling has gripped BC, with some homeowners in Richmond fearing for their property rights. Last night, there was a community meeting with members of Richmond Council. Mayor Malcolm Brody was there. He joined us at 3 o'clock. But many Indigenous leaders say much of that panic is misplaced. They argue that Cowichan tribes versus Canada decision doesn't take away private ownership, but holds the Crown accountable for lands wrongfully granted more than a century ago. So who is right? Well, here's some commentary from last night's meeting where Richmond residents asked Malcolm Brody why residents were not warned earlier about the implications of the Cowichan tribe's decision. Let's take a listen.
You're the mayor. You're supposed to know everything that's going on in Richmond. I pay my taxes to you. Why did you not reach out to us? Why did you not send a letter? You sent me a letter telling me there's to be a hearing at City Hall, okay, with no real details. It's supposed to be information. Tonight, I've gotten zero information aside from what's on a still piece of paper, which is on the website already. So why didn't you reach out to us earlier?
Do the lawyers want to address that? No, guys.
The answer to the question is that the obligation to notify is that of the plaintiffs, and that was argued in court, and the court unfortunately rejected that argument.
Those are some of the questions from last night, a very heated conversation in Richmond. Well, joining me now to talk about this issue is Khelsilem. He is an Indigenous leader formerly elected in the Squamish Nation Council. Khelsilem, thank you so much for your time today.
Yeah, thanks for having me.
First of all, just the overall conversation, not only from last night, but the conversation we've been having since this decision came down. Your thoughts on how it's being viewed, how it's being presented, and the reaction to it.
Yeah, it's definitely a landmark decision. It was a long time coming. It took a while for it to actually come out, but it also has created a lot of tension and a lot of confusion. And then I think we've seen, whether it's the leader of the BC Conservatives or the leader of the opposition federally or the premier or the mayor of Richmond, a lot of different statements that sort of misinterpret, I think, parts of the actual decision and what the judge had said, as well as the position of the Cowichan. And I think that confusion is understandably causing a lot of tension and a lot of frustration and a lot of anger that we're seeing, and you saw it at that meeting.
Yeah, I've read your Substack in regards to how you view this particular decision. And in that Substack, you wrote that you said private homeowners aren't risk. The court ruled that Crown and municipal titles were defective and invalid. Do you understand that maybe some people, a lot of people, would feel they would feel secure in their title if the same legal reasoning could apply to their land next? I mean, if we're saying the court ruled that Crown and municipal titles were defective and invalid, you can understand why taxpayers, private homeowners, will say, "Wait a minute here, that calls into question my ownership of my home."
Yeah, I think what's been interesting about the ruling is, I think, as the Cowichan tribes highlighted in their letter recently, is that Cowichan specifically in their court pleadings did not specifically target private home ownership or private properties. They were specifically targeting the government-owned ones, whereas the judge then ruled, and I think this is part of the case that's been really important to focus on, is they've acknowledged that the land is title lands of the Cowichan Alliance, that if the Crown had disposed of those lands, then that there is some sort of reconciliation that needs to happen between the Crown and the Cowichan tribes in the Alliance. And they didn't invalidate any of the private property interests that are outside of the government-controlled. But essentially, if you think about it, like the way I think about it, or what the judge was saying is, there is some restitution or some repair that needs to happen between the government and the Cowichan, and then that there's 18 months to figure out what that could look like. Throughout all of the Aboriginal title cases, going back to the Calder decision, to Delgamuukw, to the Haida, to Chilcotin, and to this, the courts have often stressed, principles of fairness, principles of good faith, principles of due process, and then largely directed the Crown to then negotiate as a form of reconciliation to resolve these issues. Mm-hmm. And I could even look at like the Haida title decision, which there was a lot of controversy about. And I think one of the things that's interesting about that was the Haida were also going to court to seek a title declaration over Haida Gwaii. The Crown ultimately decided to negotiate, so the court case was held off. And then within the agreement that came out of that, the Haida agreed to relinquish interest in all fee simple titles within Haida Gwaii, but have then asked that all of the Crown interest be transferred over to the Haida Nation. So in that case, they actually agreed to just surrender any claim or interest or seek any compensation for the private title stuff and focus mostly on the government. So these things around what happens to private title, I think, are an important conversation. I think this is eliciting that conversation in a way that we've never had before. But there are some examples of how this doesn't really impact private title holders. It's really up to the government to resolve these issues.
So, the argument can be made that, okay, in regards to reconciling, it's up to the Crown, not private owners. But even with this decision and discussion, residents also aren't given clarity in regards to whether they can sell, refinance, or insure their homes because of legal uncertainty here. That does hurt them directly, does it not?
It potentially does. I think that one of the things that is becoming concerning is that there's a lot of confusion, and then there's a lot of statements being made, and it's hard to know what is factual, if it is actually tied to the title decision, or if there's other circumstances why there might be issues with lenders or mortgages and things like that. We also saw, today there was a fake letter that was distributed in the city of North Van on a fake City of North Van letterhead claiming to represent the City of North Van and making statements around title claims and property rights in North Van, where the city had to put out a statement saying this is not an official letter. Mm-hmm. So I think that what's challenging right now is to know where are the facts and what is the truth, and it's important, I think, to figure those out. And then I think it's also important for the province to really step up here and help support private property owners in the affected area. I think the courts have been very clear that the onus of Aboriginal title is a burden on the Crown. That it is something that the Crown has an obligation to address, and that there is a high standard for them to address it meaningfully. And I think that this is where, because the Crown has refused to address these issues, they're now boiling up in this way.
So, and I don't expect you to speak on behalf of the Cowichan tribes, but in a nutshell, what you're saying here is it's up to the Crown to say, let's negotiate. The Crown, meaning the BC government, would negotiate with the Cowichan tribes, and let's say they come to a financial agreement that we would pay, and I'm just pulling a number out of the air, $100 million to settle this. In whatever the settlement is, private property rights would be protected. That would be there. That this is what it's going to take to actually sort of deal with this issue at the end of the day, just negotiate some sort of solution here, and it would probably require some sort of dollar amount?
Yeah, I think that, title recognition and the reconciliation of those interests can look like a lot of different ways, and we've seen this in different agreements around the province. One of those could look like cash transfers as compensation for the lands that have been lost. It could also look like the Crown looking at other parcels of government-owned land and perhaps transferring those in lieu of the land that has now become private title. It could look like revenue sharing on the existing government lands. It can look like a lot of different forms, and then I think it'll be up to the Cowichan to decide, and every First Nation sort of has to figure out what that means for them. Mm-hmm. But if you look at, like you said, I can't speak on behalf of the Cowichan, but if you look at the initiatives that Musqueam and Squamish and Tsleil-Waututh have done with Jericho lands and the Heatherlands, all of those came about because the nation had a claim to title. There was a government that wanted to sell off government lands. The nations stepped forward and said, hold on, we have title to these lands. And if you try to move forward in selling them, we'll take you to court and we'll probably win. And as a result of that, the government ultimately decided to negotiate. The nations got the lands and have used them for redevelopment purposes to generate revenue and also provide housing for the general public. So these things, I think, can end up being quite positive for both First Nations and non-First Nations.
Now, in the issue of Aboriginal title and whether it can coexist with fee simple ownership, what happens when these two interests conflict, let's say over resource use, redevelopment, or environmental regulations? Who would actually have the final say?
That is a complicated question that sometimes sides with the government, sometimes sides with First Nations. The courts have said that there has to be justifiable infringement in order for the Crown to be able to justify its infringement of Aboriginal rights and title. If there is not a justifiable infringement, which can include things like if it's in the national interest or if it's in the public interest and the scale of that. But I think it's helpful for many to understand that when we think about Aboriginal title, it's similar to thinking about jurisdiction. And there's lots of issues in our country. We're debating on many of them right now, where there's overlapping interests. The federal government has an interest, the province has an interest, our municipalities have an interest, and they work together to resolve those interests or to move through a process, whether that's a regulatory review process, a joint review process, or where one jurisdiction has a certain level of authority and another one has different authorities. So I think it's important to think about these things as First Nations as an order of government, that they have an interest to regulate or to have jurisdiction over certain things and then work through those together with other levels of government. And that's essentially what reconciliation means, is that there's two authorities that are working through these things together and trying to resolve the differences.
We often hear the term reconciliation, economic reconciliation. You know, my assessment of this is partially the challenge we have as a society is the provincial government, and I would argue First Nations communities, I would argue even the business community, even labor, they've done a poor job articulating what reconciliation means to the general public. I don't think the provincial government especially, which should be leading this conversation, has really engaged in a meaningful conversation. We say it, but we haven't been able to define it in a way that it speaks to everyday people in their lives. So when issues like this pop up, that I think people have a legitimate reason to be concerned when it speaks to their personal property rights. I mean, is that a fair assessment on your part that we've just done, we being a collective society, I guess, done a poor job defining what we're trying to do here?
Yeah, I would agree. And I think that there's a long history with a lot of nuance because of the various different First Nations histories that exist in our country. And then also there's just a challenge in understanding what these things really mean. So, for a long time, we've heard territorial welcomings or territorial acknowledgements where, an event begins by acknowledging that we're on the unceded territory of whatever First Nation. And, there's these concepts like unceded that go back into Canadian law that acknowledge that Indigenous nations, like in BC, didn't sign treaties or agreements with the Crown. And as such, the title continues to exist and it hasn't been extinguished, that it's a burden on the Crown. And then this turns into other kinds of concepts. And I think we as a society are kind of waking up to the fact that this is what's part of Canadian law. And I think there is a lot of work to be done to educate everybody on what this means. But the good news is that there's lots of examples. We're seeing more and more First Nations stepping into a leadership role, whether it's taking an equity project, an LNG project. There's the recent move to expand the transmission lines in northern BC, where they're offering equity positions to First Nations to participate. We've seen at the federal level loan programs created to support First Nations making economic participation in national projects. So there's different ways in which this can be understood. It's just that there's a lot of work to be done to, build that relationship between First Nation and non-First Nations communities.
Khelsilem, thank you for your time today. Really appreciate it. Look forward to seeing you in studio very soon.
Yes, thank you.
All right, that is Khelsilem, Indigenous leader, formerly elected in the Squamish Nation Council, talking about this Cowichan decision and the broad conversations and the implications of it. Hey, give me a call on the open line. We'd love to get your thoughts. What do you think of Khelsilem's comments in regards to what transpired over the last, month or so, particularly last night as well? Do you think there's actually a solution there at the end of this and they're actually headed to a better place? Or based on some of the conversations we've certainly been hearing the last 24 hours, that it does jeopardize personal property rights? 604-280-9898. That's 604-280-9898, star 9898 on your cell phone. Would love to get your thoughts. I can see why people are angry and frustrated in Richmond, but listen to Khelsilem. He said, look, there's a solution here, and I hope there is. I just don't like the uncertainty for people, especially, and I'm not saying it's happening, but I worry that, what does this mean for somebody who wants to sell their home, their mortgage, the ability to get insurance, all those types of things. We spend so much of our time working so hard in this life, particularly in Metro Vancouver with our massive mortgages. The last thing we need is more uncertainty. Give me a call on the open line. We'd love to hear from you. 604-280-9898. Let's go to Paul in Burnaby. Hi, Paul.
Hey, Jazz. We were watching a baseball game yesterday, and this never came up before. So now people are talking about it. This unceded land and property rights and that. And the conversation wasn't really that, we're all for reconciliation, but it seems the government's negotiating behind our back and coming up with these things, and it hasn't been discussed. So some of the talk was, well, what happens if we become the 51st state? BC could say, separate like Alberta wants to. Well, the First Nations aren't going to have any rights. Trump's not going to give a damn about it. Mm-hmm. And so do we really have to think about what's happening? And, I'm not sure, I'm not a lawyer, but notwithstanding, like a future government can come in and say, well, the people don't agree with this anymore. Mm-hmm. It's just getting it's like what you're saying, it's undefined. And the First Nations, they got to be careful because they're going, oh no, this is our land. I've seen the Musqueam and the Squamish leaders say that this is our land. And that's how they're negotiating it, that we're finally getting it back and we can do what we want. Well, this is, it's not going to work.
It's the challenge, Paul.
I don't think that, yeah.
Sorry, the challenge is that we don't know, and it's just, there's no transparency. The clarity isn't there. And I guess more of this has to be figured out in court. But, we didn't sign treaties when we need to sign treaties as a province. And that's the problem. So now we will have to spend billions of dollars in some sort of economic reconciliation and sign deals, which will take many years, which has already taken many decades, right? And that's our challenge. That's our problem here in British Columbia. But we cannot function if you do not have personal property rights. You just can't function as a society. And now Khelsilem says, no, you will have your personal property rights, but it's the responsibility of the Crown to negotiate with the First Nations community, in this case, the Cowichan tribes. So be it. But the uncertainty of this case that overhangs those 750 acres, those private businesses, the private property, homeowners, that's the problem. And I laid out at the feet of Victoria. They've done a really poor job articulating where we stand and what this actually means for everyday people. Because there's overlapping claims. Every community, every inch of this province is claimed by First Nations communities. So the clarity hasn't been there from Victoria, and I blame Victoria for that. Let's go to Jason in Quw'utsun. Hi, Jason.
Oh, hi. Yeah, I wanted to ask a question about the what was presented at the meeting last night, mm-hmm. where the actual judgment was set to be incompatible. So the judgment for the Aboriginal land title claim is incompatible with fee simple. And then your speaker today from the Squamish Nation was mentioning how that reparations or I guess reconciliation could look in many different ways. One of it is the government could be financing projects for them or whatnot. How is that not seen as extortion to buy back?
Jason, we're running out of my apologies. We've just run out of time. I will try to address this tomorrow. That's a good question, but that's how it's been done. It's economic reconciliation. This is how we get past this. We haven't negotiated a final treaty with them 100 years ago, 150 years ago. That's why we're in this mess. So we actually have to negotiate. And part of that is money. Part of that is economic reconciliation.